Good morning, everybody. My name is Erik. I'm a lawyer from Victoria, British Columbia, and I've been invited here to talk about a few trends in the sports that you regulate that are concerning to me and that, in my perspective, would create civil liability to you. And I'm actually very happy to follow up right after the physician talked about dehydration, because that's where I'm going to start. Just before I get started, I want to thank Erik Janice of mixedmartialarts.com. Is Erik in the room? Erik said his piece and took off. Erik was kind enough to republish some of my articles over the years. And Nancy Ill, the acting commissioner from Illinois, invited me down here to share some of my insights with you folks. Just a brief background on me. I'm a licensed judge for kickboxing, Muay Thai, and mixed martial arts with the BC Athletic Commission. But I'm not here representing the BC Commission in any way, shape, or form. I'm here very much because of my day job, which is personal injury law. I'm what the public lovingly refers to as an ambulance chaser. I sue people for a living, and I've been suing people for the past 13 years. And it's my knowledge of the combative sports regulatory system, plus my lawsuit experience that had Nancy invite me down here today. So what I want to do is just give you a quick overview of the topics I'm going to cover. First and foremost, I'm going to give you guys a crash course in personal injury law. I want you guys to understand what makes an injury lawyer tick. From there, I want to quickly let you guys know what athletic commissions look like through the eyes of a personal injury lawyer, and you might want to think of it with a dollar sign on it when it comes to a potential lawsuit. And lastly, I then want to cover 3 hypothetical cases, and death from dehydration is going to be the first one I'm going to talk about, where I'd be willing to sue an athletic commission for negligence. So in heartwarming fashion, I've named my presentation, I'm going to sue you, and I'm sure this is going to make me very popular here today, but the reality is I don't want to sue you, and there's guys like me in every state and every province. There's personal injury lawyers out there that'd be willing to take a kick at the can at an athletic commission in the right circumstances. And the reality is I don't want to sue you, and I don't want to see any of you successfully sued, because that means either a profound injury or a profound death happened under your watch. So the real reason why I'm here is to ask you guys to critically evaluate some of your current practices and ask yourselves whether there's room for improvement, not only to potentially insulate you guys against a potential lawsuit, but also to improve the health and safety standards of the men and women that you regulate. So just getting to part 1, here's your crash course in the business of personal injury law. When a client comes knocking on my door, there's basically 3 things that I look for, okay? And guys like me work on a contingency basis, so clients don't need money. When a client comes in, rich or poor, if they've got a good case, I'm willing to take it on. I'm going to spend my own time on the case. I'm going to finance the case myself if I think there's merit. And what I'm looking for when a person knocks on my door, number 1, I'm looking for either a profound injury or death. If the person's dead, it's the estate that's going to be hiring me. Number 2, I'm looking for somebody else that I could point the finger to. I'm looking at somebody who's going to be partly or wholly responsible for that injury or death. And number 3, and legally this isn't important, but on the business side, this is very important. That responsible party needs to have deep pockets. I need to sue somebody who has the ability to pay, who could either talk settlement with me, or if I have to go to trial and get a court order, that defendant has the ability to pay. Now, I want to take those 3 criteria and superimpose those on what you folks do for a living, which is regulating fighting, regulating combative sports. Number 1, injury and death. We've got that. People are injured in these sports. People die in these sports. It's happened. It's happening. It's going to happen. So the potential claimants are always out there. There's always somebody who could die under your watch, and they could point the target at you. Number 3, I'm just going to skip number 2 for a moment. Number 3 are the deep pockets. If somebody dies or if somebody's profoundly injured and they're looking to sue, they're going to be looking to the athletic commissions. And the reason is you guys all have deep pockets. Okay, maybe not as much as the doctor who just presented, but all of you folks have deep pockets. And I know some of the commissions in this room have modest budgets, some of the commissions in this room have large budgets, but legally all of you guys would be viewed reason is you guys are extensions of government. So if you guys need to pay, the money's going to be there to satisfy that check. So lawyers like me will be looking at guys like you. And so that brings me to number 2, which is fault. When can you guys be at fault for somebody dying or somebody being injured on your watch? And so that's going to be the heart of what I want to cover here today. But before I get into these 3 case scenarios, I'm going to do what lawyers do best, which is cover my own hide. I'm going to give you guys a disclaimer, okay? I can't stand here in front of all of you and give you a legal breakdown of how these cases are going to play out in your jurisdiction. And that's because we're all different in this room. Everybody in this room comes from a different commission. You've got different laws creating you. You've got different sports that you regulate. You have different rules that you're under. You have different budgets that you have the ability to spend. And you have different state laws and different provincial laws giving you different levels of government immunity. So when I give you a case scenario, the reality is it's going to play out differently from state to state and from province to province. So I don't want to talk about those differences. What I want to talk about is the common theme that weaves all of you together, because you're all different. Every athletic commission in this room is identical from a legal perspective in one fundamental fashion. And that's your reason for existing. You guys all exist for fighter safety. And since we're here in Nevada, I'm going to just borrow quickly from the Nevada State Athletic Commission's mission statement. It states that they exist, quote, to ensure the health and safety of the contestants, end quote. I'm just going to repeat that quickly again, to ensure the health and safety of the contestants. If and when any of you guys get sued by somebody like me, you all remember the O.J. Simpson trial. Almost everybody here is probably old enough to remember the criminal trial. If the glove don't fit, you must quit. Okay. We call that an anchor. When you're suing somebody, you want to put an idea in the judge's mind, and you want to repeat that again and again and again. If the glove don't fit, you must quit. Now, this won't be as witty and it won't rhyme, but when a trial lawyer sues you, folks, that mission statement of your commission to ensure the health and safety of the contestants is going to be weaved through the trial. So your actions are going to be analyzed with that goal in mind. Did you protect the health and safety of the contestants? When you made your decisions, did you keep health and safety issues in mind, or were other forces at play? And so if I'm ever on the prosecuting end of this kind of a lawsuit, I can assure you I'm going to repeat that in my opening statement. I'm going to repeat that in my direct examination of witnesses. I'm going to repeat that when I cross-examine witnesses. I'm going to repeat that when I make my final submissions to the judge. Did the commission do their job with health and safety in mind? So with that introduction in the way, I just want to tell you what's concerning me and the areas where I can see some vulnerability to you folks if something terrible happens on your watch. The first case I want to talk about is going to be dehydration. So death from rapid extreme weight cuts, which have become part of these sports and prevalent in these sports. Here's my hypothetical case. Let's say there's an MMA bout in your jurisdiction. Let's call it welterweight. And the first man gets on the scale, he makes weight flat 170, no problem. Second fighter steps up, and he doesn't look so good. He looks thin, drawn out, looks like a walking skeleton. Man's shaking a little bit on the scale. Takes a little while to get it calibrated, and bad news, you're a little bit over. And there's a commission representative right there. There's a physician right there. The weigh-ins happen publicly. And the commission rep says, hey, fighter, good news. You've got an extra hour or two in our state or province to make weight, so see you soon. So the fighter goes in the sauna, or gets on the bike, or gets in a hot tub, does whatever he has to do to suck out that last little bit of weight. Unfortunately, doesn't succeed. The man passes out. Let's say he strikes his head. Maybe there's a brain injury, maybe there's a spinal cord injury. Let's say that man comes into my office and says, Erik, you know, my weight wasn't on point, I did a lousy job, but things aren't right. That commission should have never let me make that weight cut. That commission never should have let this happen. I'm now compromised for the rest of my life. Can you sue these guys? I'd say yes to that case. I'd take that client on. I'd risk my time. I'd risk my money prosecuting that client. A famous combat sports promoter once said, when questioned by the press, about whether there's any dangers with rapid extreme weight cuts, and the man said, quote, "Nobody's ever been hurt from it. I mean, there's only so much we can do," end quote. That reminds me of Senator Moynihan's famous quote, which says, "Everybody's entitled to his own opinion, but not to his own facts." And the facts are men and women under your watch are being hurt by these practices. I'm just going to rattle off a quick list. Canadian fighter Jerk Kernelson needed CPR after losing consciousness from a weight cut. Jordan Murray required gallbladder surgery due to weight cutting. Rodrigo Dam had kidney issues caused by a drastic weight cut. Leandro Souza died while cutting weight in Brazil. TJ Cook suffered kidney failure in the ring. Yoon Young Kim suffered a mild heart attack while cutting weight. Ulysses Gomez was hospitalized after cutting weight. We just talked about it. 3 NCAA wrestlers died in the 1990s. Good stuff, Doctor. 3 NCAA wrestlers died in the 1990s because of weight cuts. Kevin Gastelum was hospitalized during the weight cut. Steve Montgomery suffered a seizure while cutting weight, needing hospitalization. Andrew Todhunter passed out while cutting weight. Local fighter in my province, Ashna Shregi, had his body shut down, quote, needed hospitalization due to his rapid extreme weight cut. Johnny Hendricks was hospitalized due to weight cut issues. Benny Madrid, transported to hospital due to weight cut issues. Yang Jianding in the Philippines died from a rapid extreme weight cut and won championship. So there's the list, okay? And you guys all know, you regulate these sports. The list is far, far greater than this. This is what's publicly reported. These are the stories that get media attention. If a lawsuit ever happens, here's where you folks are vulnerable if you don't address current practices. Weight classes fundamentally exist. Why? Can anybody tell me? Why do weight classes exist?
For fairness in the sport, for the safety of the competitor, and for a good competition among the combatants.
Thank you, Doctor. So, fighter safety, there's the key phrase right there. And I'm going to weave in why you folks exist as regulators, which is fighter safety. Here's why this lawsuit would be tempting to me. If somebody gets profoundly injured, we've got weight classes designed for fighter safety, and we have regulators allowing these weight classes to become perverted, to be abused, to become one of the greatest dangers to fighters in boxing and mixed martial arts. The weight classes are being turned on their head to the detriment of the fighters. The list that I just read out would be the knowledge base that commissions ought to have, and so commissions couldn't plead ignorance when it comes to the dangers of letting men and women become profoundly dehydrated.
Just a correction, Leandro Souza, that you said that in Brazil, that was regulated by any commission or federation and so on.
Right. No, I understand. I only point that out to show that fighters are in fact dying from these events. The heart of the lawsuit would focus on the fact that weight classes are designed for fighter safety. Commissions are allowing these weight classes to be perverted with an adverse effect on fighters. And we've got a Brazilian death, we have a Philippine death. It's just a matter of time until there's a North American death. And so I'd encourage, and there's a heated debate here shortly, but I don't have the answers. Okay? I can tell you legally what's important. Dehydration is the danger to these fighters. So finding a way to tackle that issue is what's going to legally insulate commissions. And we've got 2 sets of real difficulties here. We have fighters dying from the cut itself, and we have fighters competing before they're properly rehydrated. And if you look at boxing's death list and MMA's death list, the pattern there is it's the heavyweights that aren't dying. It's the lower weight classes that are dying. When there's a brain injury death in the ring, chances are dehydration is playing a role. So there's the common thread. So I'd encourage all of you to listen to the ARP. When they make suggestions to tackle this issue, take a look at your policies and make sure you're taking proactive steps to have fighters not fight while profoundly dehydrated and have fighters not make weight while profoundly dehydrated. If you don't, you're compromising health and safety, and if you don't, you're exposing yourself to greater risk of civil litigation. I've got 2 more topics here I want to cover, and I'm happy to tackle any questions you folks might have. I'm going to call it doping, negligent doping. Here's another perfect storm waiting to happen. let's say you're a commission, and I'll tell you right now, this doesn't apply to everybody. All of your rules are so different. Some of you folks just don't have the ability to do this. But let's say you're a commission, and you've got the ability to drug test both professional and amateur fighters. And let's say you also have the ability to drug test in and out of competition. But for whatever reason, you don't use these powers. Okay? You don't test the amateurs. When the big events come to town, you maybe test them. You don't test out of competition ever. And what happens is a culture develops. It becomes known that amongst the fighters, amongst the trainers in your town or in your state or in your province, you could dope. The commission's not looking at this. So a fighter dopes, and let's say there's a profound injury. Let's say the opponent, brain injury, spinal cord injury, whatever it is. And that clean opponent comes to me and says, Erik, I got beat. I was the worst man that day, but I never would have stepped in that ring or in that cage if I knew my opponent was doping. Can you help me? And the answer is yes, I'll take that case. I'll sue the dirty opponent, I'll sue the cheater, and it's going to be a lawsuit based on civil battery, civil assault, and I'm going to plead fraud. I'm going to say doping constitutes legal fraud, which took away the consent to fight. And I like my chances of winning that lawsuit, and that really shouldn't concern any of you, because that's the fighter. But remember what I told you folks about deep pockets, the basic elements that I'm looking for. Chances are the doping opponent doesn't have the money to satisfy the damages that my client's going to be seeking. And that's where I'm going to turn my target on the overseeing regulatory agency. If the commission doesn't occasionally use their powers to test out of competition, if the commission doesn't occasionally use their powers to test amateur fighters, where they have the statutory right to do that, I would argue we've got negligent doping testing. And you have to remember fundamentally, you folks all have the ability to test for PEDs, not to catch a doper and not to suspend that doper and not to find that doper, but you're given that power to protect the clean athletes. Going back to my mantra that's going to be repeated during any type of a lawsuit. You exist for fighter safety. You're given doping control powers for fighter safety. And to the extent that you're not catching the occasional dopers out of competition, you're encouraging the culture of doping that exists in the sport. And the clean athletes out there are being compromised. If something awful happens under your watch, there's going to be some vulnerability to litigation from a commission. So there's case number 2. Case number 3, this is sort of the elephant in the room, and it's been touched on a little bit. The brain injury lawsuit, the CTE lawsuit, the concussion lawsuit. I was asked by a reporter a while ago to explain how the brain injury lawsuit is going to play out in mixed martial arts or in boxing. And the reality is, I don't think athletic commissions have the same kind of exposure that leagues like the NFL had in the massive brain injury lawsuit that they were involved in. I don't think there's going to be an across-the-board successful class action lawsuit, and I think you folks actually enjoy a fair level of immunity when it comes to avoiding liability on a brain injury lawsuit. But here's the one thing I'd encourage all of you to keep in mind. This is the one case I would take on, okay? Fighting's dangerous. Fighters get injured. Fighters get killed. Sometimes it's the inherent nature of the sport. There's no lawsuit to be had there in most circumstances. But let's say a fighter's been had a celebrated career, has had many bouts, announced his retirement, and then like many of these men and women, they get that itch and they decide to come back. And over this fighter's career, especially on the latter part of it, there's been some noted changes in the way they act and the way they present themselves. Maybe he has some dizziness, maybe there's some disorientation, maybe there's some memory loss. People that know him know that there's some signs of social instability, there's some erratic behavior there. But this man has a tremendous record. You look at Fight Facts or these other programs that are there, and he'll get his gold star or his 4 out of 5 stars. And he comes for a license, and your commission says, yes, here you go. And the doctor signs the form, says this man is fit to fight. Let's say this man gets beaten soundly, and all of these problems, all of these cognitive issues that the man had are suddenly compounded. And the man comes to me and says, Erik, I chose a rough career. I knew what I was getting into, but I didn't know it was going to be like this. That commission should have never given me that license. I'll tell you what I'll focus on in this lawsuit, and I'll tell you right now, it's an uphill battle. I think it'd be tough for me to persuade a judge that a commission is responsible for brain trauma, but I'll tell you the way I would attack this. I would take a look at your licensing requirement forms for the fighter. I would take a look at the forms you have your physicians fill out that sign off on whether the fighter is fit to compete. And I would ask whether you're keeping current with medical science, and are you screening for the early onset symptoms of CTE? Okay, the one thing, and here in Las Vegas, it was mentioned earlier, the Lou Ruvo study at the Cleveland Clinic is going to produce tremendous data about brain injuries in combative sports. I encourage all of you to be completely up to speed on that and take a look at the early warning signs to decide if or when you guys should pull the plug on a fighter. Because the one thing that's become crystal clear, there's a lot of doctors here that could correct me if I've got this wrong, but CTE is a disease of mileage. The one thing we know is that there's only so many hits to the head a fighter can take. You as regulators who have to decide who can get licensed and you have to make that decision with health and safety issues in mind. You have to have sensible policies in place about when to pull the plug. And they can't be policies drafted 20 years ago that say, is the CT negative and is the MRI negative? If so, this man should be good to go. The reality is there's too much mileage, and when a fighter is showing signs of too much mileage, you have to make sure you have policies in place that can pull the plug. If you don't, I'd be willing to take a kick at that kind of a claim. And I put it this way, I guess. Combative sports are dangerous, and it's never safe for anybody to fight. But it's like smoking and cancer. If a patient goes to the doctor and says, hey doc, how many more cigarettes can I have before I develop cancer? I don't think the doctor can give an answer. If the fighter says, hey doc, how many more hits to the head can I take before I develop CTE, the doctor's going to say, I can't tell you as well. In both those scenarios, there's something the doctor can tell the patient. With smoking, the doctor could say, you've got cancer now, you should quit. With CTE, the doctor could say, if you're being honest with me, you're telling me about these symptoms, it looks like you might have some early cognitive dysfunction. It looks like you have symptoms consistent with CTE. And I would just encourage every regulator in this room with a view towards increasing your standards for fighter health and safety to stay current with the science that's coming out about CTE and to make sure that your forms and your application process are up to speed and are asking the fighters and asking the doctors signing off on the fighters all of the right questions. Thank you, folks. That's my presentation. If there's any questions, I'm happy to take them. Otherwise, I'm eating into your lunchtime.
Where's the mic?
Right here.
Right here.
Right here.
Come on, Mark.
As you may know, casually speaking, I've probably been involved in the majority, not all, but the majority of the catastrophic injury lawsuits involving boxing in the United States over the last 20 years. I think the presentation was very good in the sense that you should all be scared to death to the extent, and I don't think this is really generally true, but to the extent that you don't do everything you can to stop injuries because you want to, which I think everybody in this room really, really does. There are liabilities, as counsel has pointed out. I don't want people afraid to do their jobs, people leaving either the medical profession was done, or in terms of being ring physicians, or being so afraid you don't want to be a commissioner. There are tons of immunities for state bodies, and which most of you are, except the tribes. That's a different story entirely, and I'm not going to deal with that. With respect to dehydration, we have, and I kept quiet about that, but for 20 years, literally easily 20 years, I don't know where Greg is, but we've been involved in this debate. There's been some progress, but not a hell of a lot, really. It's the same debate, periodically. Dave, the weigh-in, people say, I believe, but that doesn't work well with fighters because they're not NCAA athletes. But I think it is time to address that, and because of this, I did want to speak up. But one of the things you should all do is, and many commissions are doing it, you should all inform the fighters under your jurisdiction of the risk of inappropriate dehydration. That provides a large measure, just as the Muhammad Ali Act requires you to inform fighters of the risk of brain injury. That same thing should be done with respect to the risks of dehydration. I've seen that some commissions have done it. I've seen the paperwork. I would suggest that you all do it. And whatever commission has appropriate paperwork, I think California does. I may be wrong, but in any case, you should share with the rest of the commissions because it's a good way to avoid. Primarily, once the fighter is informed, the primary responsibility lies with him and his trainer. But I'm sorry, what's it? Possibly the manager. See, the managers often don't know, but the trainer does. Okay. Much of what you spoke about, I kept having flashbacks to the Joey Gamache lawsuit in New York. Ultimately, causation was not shown. He suffered injuries, and the commission was not held liable, although there were some nasty interim opinions against the commission. So don't be too fearful, but try and inform the fighter and the trainers about risks and the right way to avoid those risks. And that, in my opinion, is the best way to avoid much liability in terms of what was discussed. Now, there are other situations, to put it bluntly, where either the physician or the commission just plain screwed up badly. I've been involved in those. I've seen them. No one's happy about them, and there should be liability in those circumstances. But to the extent that you just try and do your job the best you can, don't be influenced because you want a fight to go on, you got a pretty good level of protection under the state laws, immunity laws.
Yeah, thank you very much. I guess I'll just finish on the note though as well, and you're absolutely right. When you go from state to state or province to province, there are different levels of immunity. I'll bore you all to tears with those breakdowns. I'll tell you this though, to the extent that there may be immunity with respect to any of these topics, I encourage you just from a perspective of fighter safety to be the driving force, not immunity for the actual lawsuit.
Yeah, one last question. Good talk. Learned a lot. I think it's good information everybody needs to know. You mentioned that you would happily take and file a lawsuit when the fighter comes and says he shouldn't have been fighting because he was dehydrated. You would take that and finance it yourself. I'm going to ask a question. I think I know the answer, but I want to hear you say it. Are you less likely or as likely to take the lawsuit from this fighter who shows up at your office and says, the damn commissioner or that damn doctor wouldn't let me fight because he said I was dehydrated and now I've lost my career or I've lost my chance of being a professional fighter?
No, wouldn't touch that lawsuit. That's the nature of the beast, and that's the commission doing their job. Thank you very much, everybody.